however, I do not see a plea questionnaire filed, and usually you're right on top of it, so I'm gonna guess that there's something that you're gonna let me know.
Yes, Your Honor, I'm asking to withdraw from this case. It's a public defender appointment. I can file a written proposed order so the public defender's office can appoint her for a second attorney. I don't really want to get into too much of the.
I understand, and I'm going to tell you, Mr. Krakowski. Here's the thing. Generally, when an attorney when either an attorney asks to withdraw, especially a public defender appointment, or a defendant asks to get a different attorney, I have a full-blown hearing because, quite honestly, you don't have a right to choose your attorney. Okay, and I'm going to state on the record right now that Ms. Landgraf is one of the best that we have. So I don't know what's going on, and I don't care what's going on. The fact that she is a good attorney, and the fact that this is your first request to change, I'm not going to go through the rigmarole, whatever. Put it on the record. You know how to spell it. Say it. So I'm not going to do that, but I will let you know again. You don't have the right to choose your attorney. So the fact that you're requesting to have another public defender in this instance will be fine. But if it happens again, I will go through the necessary factors that I have to determine whether or not I would allow the withdrawal. I don't always do that. Okay.
Okay.
All right. So I will allow you to withdraw, Ms. Landgraf. Please notify the public defender's office as soon as you practically can. If it'd probably be good if we get an order, because I didn't know that this was going to be the request, so I don't have a proposed order filed.
I'll file that.
Okay, but so what I'm going to do right now is I'm going to set another status not too far down the road, and I'm going to tell you that if it's a matter of rethinking or doing something of that nature, I'm going to get it set on the trial calendar so we can get the matter continuing to move. Okay.
Okay. Thank you.
Do you have your calendar?
Yeah.
I'm going to schedule you for 2 o'clock on September 9th. 2 o'clock, September 9th.
Do you have school on day or are you?
All right, you can come up.
She's checking her calendar. She's starting college next month, so I just want to make sure it's not
Yeah,
gonna.
but this is
Right.
court.
I understand. I'll figure
And
it
that's
out.
when I have it. That's the only time I have it. Well,
Okay.
or
Okay.
September 10th at 10:15. But I'm going to tell you, I'm setting it on the 9th at that time because I know I'll have public defenders here.
Okay. Okay, that I'll make it work.
Okay, September 9th, 2 o'clock. We'll see you then. Come and get your notice and you are free to leave. Attorney Pilney, can you hear me?
Yes, I can. Good morning.
Good morning. We will go on the record in the matter 26 CV 73, Old National Bank versus Jan Lodemeyer et al. Appearances are we have Ms. Lodemeyer appearing in person without counsel. We do have attorney Sam Pilney for the plaintiff appearing by video conferencing with approval of the court. We were first set here for a default by affidavit request, and then now a plaintiff has asked and motioned the court for summary judgment in this matter. I do note that Ms. Lodemeyer did file an answer in this case. However, the answer essentially was admitting to owing the debt and saying that you wanted to pay it back and you want to accept that responsibility. You just needed some time to do so due to life circumstances.
Correct.
Correct? So, Mr. Pilney, were you or anyone else from Old National Bank able to speak with Ms. Lodemeyer about this situation?
Yeah, the bank did reach out to Miss Lodemeyer. They tell me multiple times to make arrangements for payment, and to date, no payment has been received. and I have instruction to move forward with the foreclosure.
All right, and so you're gonna ask to move forward with the foreclosure, and we can proceed with that, but that would still allow Ms. Lodemeyer to cure and to bring herself current, correct?
Correct. Yep, it would require the full loan balance, and I'm happy to provide that amount to Ms. Lodemeyer on the record or off the record via phone or email, if whatever is their preference.
So, do you understand what he's saying, Ms.
Yes, I
Lodemeyer?
do. The problem with contacting me on phone, I work from 6 a.m. to 6 p.m. As a dispatcher, I cannot take personal calls at work because my mind needs to be set for emergency calls that come in. So yes, it's my fault, but I don't have people to contact after 6 o'clock at night or before 6 a.m. So I'm kind of stuck with
So
not being able to communicate with them.
what I'm hearing from you, Ms. Lodemeyer, is that you understand, you accept, and you're acknowledging the debt and that you owe it.
Yep.
You just haven't had an opportunity yet to actually connect.
Correct. Most banks close at 5 o'clock. I get off work at 6 p.m. Okay. As a dispatcher, I suppose I could take a personal phone call, but if 911 comes in, I would have to disconnect with
So
the personal call.
What are you doing for today?
Today, somebody's covering for me right now.
Okay, and is somebody covering for you for as long as it takes for this case?
Yes.
Mr. Pilney, do you have the ability to speak with Ms. Lodemeyer right now?
Yeah. On a breakout room or, well, I'm not sure how the court
no.
would arrange that. Yeah.
What I would do is I would briefly adjourn, I would adjourn this hearing. I do have another hearing that was double booked with this hearing since it was originally requested as an default by affidavit. So I can move on to that matter, which is a contempt hearing. And then that'll give you and Ms. Lodemeyer the opportunity to discuss the case, do the thing. We'll come back, we'll go on the record, and we'll go from there. Does that work, Mr. Pilney?
Yeah, that's fine.
Ms. Lodemeyer,
Yes.
let's get a telephone number for you, Mr. Pilney. Do you have your cell phone and you're able to call right now?
I would have to go down and get it. I didn't bring it to court because I don't.
But it would be
Yeah.
now?
Yeah.
Okay.
Yep.
What's the best number for her to reach you?
715-430-6810.
All right, so she'll probably need about 10 minutes to run to wherever she needs to go to get her telephone. Give him a call, talk to him. I'm gonna move on to my other matter, and
Okay.
I will recall this case, okay?
Okay.
All right, thank you.
Thank you.
Thank you.
All right, Mr. Pilney, you can disconnect from Zoom and then call back on Zoom once you're done speaking with Ms. Lodemeyer. That works.
Disconnecting from Zoom frightens me, so I'm just going to mute everything.
That is totally fine.
Thank you.
All right.
Here's my 4 exhibits for you.
We will go on the record in the matter 24 FA 78, in re the marriage of Michelle Phelps and Richard Chanel Jr. Appearances are we do have Mr. Chanel appearing in person without counsel. We do have Ms. Phelps appearing in person with counsel Kathleen Gionis. We're set here today for a contempt hearing. The parties were in front of the court on June 2nd, 2026, which the court did hear and contested divorce and did make final decisions and rulings as it relates to the marriage at that date and time. The court did issue a written decision on June 9th, and shortly thereafter on June 11th did do with findings of fact, conclusions of law and judgment of divorce. However, since the time of the divorce and since the court issued its final order on the property with certain deadlines, plaintiff Ms. Phelps or petitioner Ms. Phelps and through counsel is alleging that Mr. Chanel is in contempt and has done various things. Is that all correct, Ms. Jonas?
It is.
I'm going to have both parties, Ms. Phelps and Mr. Chanel, please stand up, raise your right hand and be sworn in.
Do you affirm that the testimony you're about to provide in this matter should be the truth, the whole truth, and nothing but the truth?
Yes.
You may be seated. All right, Ms. Jonas, you may begin.
I intend to call Michelle Phelps as a witness.
Well, we were only set for a half an hour with this, and unfortunately, this was double booked, not your fault. The court will accept offers of
Okay,
proof.
all righty. One of the allegations is that the motorcycle, is this called a nanny bike? No,
Harley.
the Harley Shovelhead.
And what I
It-
recall from reading the affidavit and the motion was that the motorcycle was essentially stripped.
It was, and I have here exhibit 1 is the before picture, which my client had. And then exhibit 2 is the after picture, how it was delivered to her, essentially stripped. Those particular documents are also attached to the affidavit as A and B. So those are exhibits 1 and 2. Exhibit 3 is an itemized repair and parts estimate that my client personally prepared by researching the cost of parts and labor. And that will show that the total estimated repair and restoration value is $4,801.16. That's on the motorcycle.
When did she receive the motorcycle? When, if she were to be providing testimony, when would she state that she received the motorcycle?
It was after the deadline. The deadline was the 26th. Do you remember the date they returned it?
It was there by July 3rd.
It was there by July 3rd. She signed her affidavit on July 7th, and in that interim, he had returned it in the condition that you see on exhibit 2. He also had, before the divorce, removed a 75-inch TV, which he was awarded, but he then proceeded to remove the 68-inch, 65-inch television, which was awarded to Ms. Phelps, and that she valued that in her exhibit number 3 at $398. He removed 2 items that were gifts to her from the children. One is a photo of looks like a Scottish cow with horns, and the other is a clock that the children gave. The judgment provided that he was not to remove anything from the home without her consent, and she did not consent to those things being removed. That is exhibit 3. And then exhibit 4, and by the way, I have given Mr. Chanel copies of all these exhibits, is a 4-page time list that I ran off yesterday, highlighting the time that was put in on this matter, a detailed description with the rate of $375 an hour, which is the rate that Ms. Phelps has paid all along. And that amount came to $1,255. This does not include today, which I am estimating 2.5 hours, because that includes travel time, for attorney's fees. And so I would submit these documents as offer of proof.
And Ms. Phelps, all that your attorney has stated on the record, while looking at the exhibits, that would be your testimony?
Yes.
Was there anything that she misstated?
No.
Thank you. Anything you want to add?
No.
Mr. Chanel, have you received copies of these exhibits? Any objection to the court receiving them?
Yeah,
What is your legal objection?
well,
You can provide testimony as to why you may not believe that they are true and accurate, but what is your legal
oh,
objection?
wow.
You're just contesting what,
Yeah, it's like,
Amy.
this ain't right.
all right, so the court will receive the exhibits. Anything further you want to add at this time, Ms. Jonas?
Did I cover everything? We are asking for damages in the amounts that I stated for the motorcycle repairs, replacing the television, and we are asking for the return of the photo of the Scottish cow and the clock, which were gifts from Ms. Phelps' children to her. Did I get everything?
Mhm.
And we're,
His children as well,
I don't,
Yes.
okay, I guess they are.
the couple's children.
Okay.
Gave them to mom.
Yes. And then attorney's fees in the amount of $1,255 plus for estimating 2.5 hours today at $375 an hour. I might add that the parties have an offer on the house. Right now, the closing is tentatively set for October 1st. And so there will be funds available if the court awards damages in addition to what you awarded in your decision. We are hoping to obtain an award of damages and attorney's fees in the form of a court order so that whatever is awarded can also be deducted from Mr. Phelps' share of the sale proceeds of the house.
So it's tentatively going to close on October 1.
Yes,
And what is the accepted offer?
$305,000. And there's a mortgage, right?
Yeah, I think I remember from,
Yeah.
or I can go back to the divorce notes.
Mhm.
Okay, Mr. Chanel, now is your time to tell me anything that you think is incorrect or why you believe that
Okay,
she's wrong.
this motorcycle, this picture was taken way, way long ago. The bike did not run when I got it. When I received that bike is how this picture is. That's how I
When
received
you're
it.
saying this picture and this picture and this picture, you
Right.
need to identify which picture.
This
you're-
picture was taken a long time ago.
So again, they're marked.
Yep. Exhibit 1. That picture was taken years ago. Okay, I had John from the other guy's bike shop try to fix this bike. It would not go. Those tins and tanks that are on that bike were not for that bike. I bought them for my other bike. Same with the handlebars.
So where are they now?
They are at my house because they were not for that bike. That bike in exhibit 1 is a dyno. And those tanks, the fenders and everything, stay Heritage Softail on it. That is not a Softail bike.
That doesn't matter. Were they on there and were they being used?
No, that bike never ran. It did not run. It was literally taken apart in my mom's garage. You know, I was slowly redoing it. I pulled the motor out, redid it all, because when I bought that bike, it was in pieces. I've been slowly redoing it. It never ran. It never ran. We had it fired once and it never ran after that. It was torn down. I gave her the original tanks, tins, handlebars, cables, everything that was with the bike, I gave to her. I gave her her Nani's bike, let's say, not Rick's bike. I gave her Nani's bike.
So were those pieces, the orange pieces on exhibit 1, were they installed on the bike, screwed on the bike? Or how were they placed?
In that picture, yes, they were, but at the time, that was only for a brief moment. That was never intended to be on that bike. It was for my other bike. Because it's not the brand of that bike. That bike shown in Exhibit 1 is a Dyna, a totally different model from the Heritage Softail, which I wouldn't let fly on any of my bikes, because why would you run something different?
So I'm hearing that it's the same bike, just parts that don't belong on that bike?
Yes,
So when were those parts that you say don't belong on that bike removed?
as soon as I tore it all back down,
When would be,
literally right after this picture,
which would be,
years ago,
give
probably
me an
like
idea.
5 years ago.
You have an idea. June, July, August,
Well, it'd be during
2021?
the winter time, so November, December.
Of what year?
We could say back in 18, 19.
2018 or 2019?
Yes. I mean, the bike never ran. I mean, I left it with brand new tires on it that, when that bike was a basket case when I got it. It come in pieces.
But when you got it, did it come in pieces as Exhibit 1?
It never even looked like that.
What did it look like when you got
It
it?
didn't have the bars. It looked like this,
Which would be,
Exhibit 2. I mean, I was trying to get it up and going, and then, yeah, because we were supposed to go through her mother's ashes and her stepfather's ashes, go bury them, but that never happened because we never got it running.
okay. Now, as to the TV, the clock, and the picture,
Okay, the TV, Michelle was not living there at the time, she'd already moved out, right? So I asked her because, do I get any of the house furnishings, whatnot, she wasn't there, so I figured, all right, well, the clock, yeah, I probably shouldn't have took that. But the picture, she has moved out recently before, and she's left that picture. She never took that picture. So I figured that was mine, so why couldn't I take it?
well, were you here on the date of divorce when the court
Yeah, I was here.
issued its order?
Yes, but she was moved out already. I said, I'm trying to be civil with her and trying to get along with her, but she won't respond back to me or anything else. And I'm like, Michelle, so I have to go through my kids to, hey, can you ask your mother this or whatnot? And kids are, well, Dad, we don't want to get involved, we just want to get along with both you guys. But my youngest, she has been trying to get with Michelle, Mom, can you at least answer them,
Do you want the picture?
Not now. If she wants it, she can have it. I brought it with, it's sitting in my truck, same with the clock, same with all the stuff that came on this bike is sitting in my truck.
So you didn't return all of the stuff, or are you talking about the orange parts and those things?
I'm not talking about the orange parts because those
What
weren't
parts are in your truck?
the ones that came with the bike. They weren't on it, but they came with it.
Which would be?
The tanks, the fenders, the handlebars, the cables, anything that was with the bike, that we got when we bought it.
Why didn't you provide those parts
I
to
did.
Ms. Chanel?
I did.
Ms. Phelps.
I brought them to the house. And that bike was delivered on the 26th.
All right, Ms. Jonas, do you have questions for Mr. Chanel?
I still have, all right, the TV. Yes, I did grab a TV at the time, but then when we were broken up and I was working in Montana, I did buy some other TVs that should have been mine, but she took them too. It's my 60-inch TVs. So I was like, well, I'll give you your TV back when I get my TVs back. I mean, fair is fair.
We already had the divorce. You only asked for certain things. The court ordered you certain things. All other things went to Ms. Phelps. Right?
Well,
That's what it
I-
says. That's what I said.
okay.
And at the time, you're like, I'm done with it. I'm done. I just want to be done.
Well, I do want to be done, and I'm trying to be civil with her. I thought we could get along and everything, and still talk, and, I mean, we got a marriage wedding coming up for our daughter, and we have to be civil and talk, and it's like, why can you not just talk to me? I mean, we could have figured this out without coming to court today. We could have, I don't want to fight with her. I still love her, Michelle. She's the mother of my children, I don't have a hateful bone for her.
All right, so I'm hearing he'll give back the TV, the clock, the picture.
I'll give it all back to her.
The issue is the motorcycle, and quite honestly, even with the offers of proof, I don't have any identification of what parts, so that one's still kind of out there, because I don't think it's been proven by what's been stated.
Okay, she did inform me that photo, you took it, right?
Yeah, it was in 2024.
Did you take it?
This, well, it wasn't.
Did you take it?
My son had that picture.
Okay, her
Hey,
her
you might
son
have got
took,
All right, yep, so her son took the picture. He's not here to testify. I don't know anything.
Okay.
So with motorcycle,
she's had the picture since 2024 of that particular motorcycle. It did look like that. That's what she was expecting to get back. I guess that's about all we can say. He had to take the affirmative step of taking all of those things off, assuming that the day that we were here for the final divorce, it was in the same condition as is shown in Exhibit 1.
and I believe at the date of divorce, Ms. Phelps did confirm that it was not running. It was not a working motorcycle,
Correct, it may not have been running, but it looked like that.
but it had the orange fenders and tank and those things.
Yes,
All right,
Those were just sitting on it at the time because of lack of space of putting it. They were just resting on it.
you told me they were screwed on.
In this picture, they were.
They were. So here's
But
the
then
thing.
I
the
tore the
court-
bike apart because
What
we
I'm
were
going to
redoing.
do right now is I am ordering that the TV be returned, the clock be returned, the picture be returned, and the parts that are in this picture, the orange parts, be given to Miss Chanel. It wasn't running at the time of the date of divorce. Both of you confirmed that. So the court's not going to order $4,800 for him to fix the bike that wasn't even working in the first place. So all of the parts that he has in his car right now that he says are original parts, plus the orange parts that the court can see in Exhibit 1 shall be returned within 1 week. As to attorney's fees and costs, Mr. Chanel, did you attempt to contact
Yes,
Ms. Jonas?
not Miss Jonas. I attempted to contact Michelle, I'm trying to be civil with her and get along and we can work this out, it's why
She didn't
can't,
want to talk to you,
I guess not. So,
and you didn't try and contact Ms. Jonas.
no.
And
So
Your
as it
Honor-
relates to the or to the attorney's fees, those are granted.
thank you.
We did come for reasons that he took things that he should not have taken.
And so that's for what's on Exhibit number 4 plus today.
Plus today.
All right, thank you.
But as to the motorcycle, that was very iffy at the date of divorce as well. So I don't know what condition it actually was in, when, where, and how. But I do know from this picture at one time, it had the orange parts that were installed and screwed on it, whether or not they were for that bike or not, they were a part of that bike at one time. Therefore, those must be returned as well with the original other parts that are in his truck right now. So you have those parts in your truck right now?
Yep.
So when we're done here, deliver those to Ms. Phelps. And then the TV clock, the picture, and the orange parts for the bike must be delivered
I have the
within 1
TV and
week.
the clock, or not the clock. I have the picture and the clock with me also.
You just bring it to the house.
You want them brought to the house?
Mhm.
She would like them brought to the house.
All right, so 1 week to bring everything to the house, okay? You
Yep.
want to go do that right now, but that does include that other 65-inch TV. Okay? Anything else, Ms. Jonas?
No, thank you.
Mr. Chanel? Then we are adjourned. Thank you, Ms. Lodemeyer. We will go back on the record. Same appearances as previously noted, 26 CV 73. Ms. Lodemeyer has had an opportunity to speak with Mr. Attorney Pilney for the plaintiff. Mr. Pilney, please update the court. Where are we going? What are we doing here today?
We did have an opportunity to speak. I gave Ms. Lodemeyer the total payoff amount. We kind of walked through the complaint that sets forth the foreclosure process, including the redemption period. I let her know that unfortunately I do not have authority today to offer any delays in the foreclosure process, but that it would obviously she would retain her right of redemption in this case, and she does have the full amount that would satisfy the mortgage and allow for the redemption. So that's where we're at now. As far as the bank is concerned, we would ask that we move forward with the judgment of foreclosure, default judgment against portfolio recovery, the junior lien holder, as to priority, and get a redemption amount or a judgment amount and a redemption period of 6 months.
All right, Ms. Lodemeyer, do you understand what Mr. Pilney is asking of the court?
Yes,
And I believe the full payoff, at least of what was in the affidavit, is $56,850.69,
correct. It's a little higher than that, but
but plus the interest that
Right,
it
yeah.
accrues. And so, Ms. Lodemeyer, you understand that and you accept that?
yes,
And so you understand that your answer really had no defenses in it?
yeah, I know.
Okay. So what the court will do is I'm going to grant the summary judgment on behalf of the plaintiff based upon all of the information in the affidavit and on the stipulation by Ms. Lodemeyer. She has the payoff amount. You have a 6-month redemption period.
Okay.
And here's the thing, Ms. Lodemeyer, as Mr. Pilney said, an attorney that is working for a bank, he only has so much authority
Yep.
to do something during today and for this hearing. Something could change. You can call and speak to somebody else there or ask him try and continue to negotiate and work on this. This happens all the time.
Right.
Okay.
I will have that within a 6-month period. I'll have all of that cash within that time, so-
Excellent. That is really great to hear. That makes the court happy. That makes Mr. Pilney and the plaintiff happy. I'm glad to hear that. So thank you. The court will sign the summary judgment order. We are adjourned. Thank you.
Thank you, Your Honor.
Thank you, Ms. Lodemeyer.
Thank you, sir.
Oh, it's Olivia's turn. I think she wanted you to watch her too. Show you the after court stuff.
We will go on the record in the matter 26 CF 21 State of Wisconsin versus Megan Perkowski. The state appears through District Attorney Kevin Schmidt in person. Ms. Perkowski appears in person with counsel Renee Landgraf. We're set here today in this matter for a plea and sentencing.
I didn't subpoena him, and his opinion is contrary to mine, so I don't know why I would.
No, that's up to you and or Mr. White.
I believe it was Dr. Stepp. Is that who you're referring to?
I
Or,
think the first doctor was Dr. Bulgaris. Oh, no, Dr. Stepp.
Yeah.
Yes, it was just signed. The cover sheet was just signed today.
okay, so Dr. Stepp's not available today?
Not unless you subpoenaed Dr. Stepp. And the court, and as the state stated, it's contrary to the state's position, therefore they did not subpoena the doctor, and that is not the court's responsibility. Are we proceeding with Dr. Brady?
Your Honor, so long as that Your Honor can take judicial notice of Dr. Stepp's report and the findings, the results that were in there.
You stipulate to the court receiving the report, Mr. Schmidt?
Yes.
The court cannot receive the report or take judicial notice without having the doctor provide testimony.
Okay. Then I think we are not prepared to move forward today.
Might I make a counter proposal? We have one doctor. I have two other witnesses. Why don't we take the testimony we can? And then if they want Ryan Stepp at another, we schedule that.
That's what I was going to say, and quite frankly, the court can deny the request for Dr. Stepp because he should have been subpoenaed for today. So let's move forward with Dr. Brady and or the other two witnesses.
Thank you. I'd start with Dr. Brady.
All right, Dr. Brady, can you please say your first name?
Lissy.
Okay, Lissy. Dr. Brady, please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you. You may begin.
Could you state your name for the record, spelling both your first and last name?
My first name is Lissy, Lyssi. My last name is Brady, Brady.
How are you employed?
I'm currently a contract psychologist at Psychological Assessment Services. It's a private practice.
Could you briefly describe your qualifications and training as it relates to doing competency evaluations of defendants in criminal cases?
Yes, I received my undergrad, my bachelor's degree in criminology and criminal justice from Arizona State University in 2016. I received a master's in clinical psychology from Pacific University in 2018. And then I received my doctorate of psychology in clinical psychology with a forensic emphasis from Pacific University in 2023. And then I completed a postdoctoral fellowship at Mendota Mental Health Institute and Sandridge Secure Treatment Center. I provided competency evaluations as well while I was at Mendota.
When you say Sandridge, were you doing 980 work?
Yes, and treatment.
Okay. Then did you prepare a report related to a Christopher Stewart involving Burnett County case 24 CF 163?
Yes, I did.
And in that report, you ultimately concluded that Christopher Stewart is not competent but likely to regain, correct?
Correct.
What were the materials you relied upon to create this report?
I received collateral information, so his criminal history. I received the criminal complaint. I also conducted an interview with him where we discussed his background and also, went through all of the competency knowledge and materials. And then I also conducted intellectual testing, which was through the Wechsler Adult Intelligence Scale 5th edition.
Okay. So on page 2 of your report, it lists sources of information. Is that the totality of what you use as collateral resources?
Yes.
And your other evaluations and behavioral observations, that was an in-person meeting.
That is correct.
How long was that meeting?
That one was around roughly 227 minutes, I believe. We met from 1 p.m. to about 4:50, 4:47, somewhere in there.
As part of that interview and evaluation, did you ask Mr. Stewart if he had had any other evaluations previously?
Yes.
What did he say?
He said he did, and then we went through and reviewed the background information from that report as well.
You're referring just to the competency report by Mr.
Oh.
or Dr. Stepp?
Yes, I'm sorry.
Did he talk about another mental health examination in November of 2025 by Range Mental Health Center?
We discussed that he had some treatment that was completed through an alcohol substance use program.
So he only mentioned alcohol, not mental health?
I believe so, yes.
Okay. So I want to start first with some things that Mr. Stewart said to you that you referenced on page 3 as it relates to educational and vocational history. On page 3, you indicated that Stewart claimed he was fired once because they couldn't believe I could haul gas that fast. Did you talk with him about, is that all he said on that topic?
Yes, I believe so.
And he said that he was fired from another job because he went to treatment for alcohol.
That is correct.
Did he blame the treatment for the job loss or for the alcoholism?
Neither. It had to do with him missing work to go to the treatment.
Okay. You wrote that Stewart reported a history of alcohol use. Could you give more detail about what exactly he said?
Am I allowed to refresh my memory from my report?
Yes, you may refresh your recollection, and once you have refreshed your recollection, please put your report back down.
Okay. Okay. He talked about having a longstanding history of difficulties maintaining his sobriety, dating back to whenever he was residing in Minnesota as well, and he had some treatment there, and that he has also had treatment here. And he reported previously excessive amounts of alcohol use.
What did he report for present alcohol use?
He said that he has not used alcohol.
Did he believe that he had had any past difficulties related to alcohol? As in, did he attribute, past cases or relationship or job issues to it?
He admitted that he did have difficulties with alcohol use. He had reported experiencing cravings, and having, some interpersonal difficulties with it.
And is alcohol use and alcohol use disorder something that would need to be ruled out for things like comprehension or cognitive issues?
Not necessarily, especially if, because especially with their prior report where Dr. Stepp had interviewed his mother, she had mentioned that there was already a history of memory issues dating back to even when he was younger.
So wouldn't that answer be yes then? You ruled it out by talking to his mother?
I did not speak with his mother.
I know, but what I'm saying is, a lot of issues related to cognition or memory loss could just be involved with intoxication, correct?
Your Honor, I'd object. I think it's leading and it's argumentative.
Sustained.
You did a number of tests with the Wechsler test on Mr. Stewart's cognitive abilities, correct?
That is correct. I did the standard battery with that.
Could you
Or
walk us
subtest.
through, those tests and what exactly those mean? I'm talking about what starts on page 5 of the eval, where it's talking about things like working memory, cognitive proficiency index, et cetera.
Yeah, so there are several subtests that are sorted into indices. And those are the indices that are listed on there. So there's verbal comprehension index, which looks at verbal reasoning skills. There is fluid reasoning, which looks at the ability to sorry, that looks at the ability to like apply construction and like math reasoning and things like that. There's working memory index, which looks at the ability to have information provided and then to retain that information for a short period later. There's the processing speed index, which looks at how fast someone can take in visual information and then apply that information in decision making. I think I'm missing one. I'm so sorry. Oh, and then the visual speed index and that, or not visual speed, sorry, visual spatial index. And then that one looks at like construction of like using blocks and patterns to formulate answers.
Okay. So I want to ask you some questions to try to boil this more down into something understandable by lay people. Would it be fair to say these tests showed incongruities between different types of cognitive ability?
There were differences between them, yes, between his performance on different tests.
So the test showed he has like adequate reasoning ability and abstract reasoning, correct?
That is correct. It's average.
per-
It fell in the average range.
Where he runs into trouble is how quickly he processes information.
And his ability to retain the information as well.
Are you talking about memory?
Yes, the working memory index and the processing speed index were both, I believe, in the very low range.
Wouldn't working memory only be short-term memory?
Yes, that's what I meant, like in the short term. Yeah.
But he has no long-term memory issues, at least from these tests.
So this test doesn't look at long-term memory. So I'm not able to speak to that.
So this working memory test, does this measure the working memory capacity? That is how many items a person can have in their mind, or something else?
So the way that the working memory does, it does look at some smaller like portions of like numbers and things like that. However, we can't use this test to say they can only hold a certain amount of information in their short-term memory.
I guess what I'm trying to ask is, what aspect of the working memory does the working memory index measure?
Could you clarify the question a little bit? I'm sorry.
Does it measure, you said it can't give a specific number as to how many items a person can keep in their mind. Does it measure the capacity, even if it doesn't give a specific measure? Does it measure in a person's ability to use the working memory? Does it measure how quickly they can put things into working memory and take it out?
It doesn't quantify that. This is more so stating, that they're able to just temporarily use that information, like retain and use that information. Typically with this one, it's between like 5 and 10 minutes later sometimes.
Okay. So all these tests really say is how quickly he can process information and the adequacy of him recalling things 5 to 10 minutes later.
Yeah, that is correct. And also in the moment, I'm sorry, it's within the moment. So for example, one of the tests, I read off some information to him and he has to give that back to me. But he doesn't get to practice those things. I can't repeat them. It's just that one chance.
Okay. Were there issues shown from the Wechsler test aside from the processing speed or the working memory index?
I believe he fell in the average range on the other subtests or the other indices.
Okay. So I noticed for working memory index, you wrote very low, and for processing speed index below average. Could you give an explanation as to what those mean in relation to, general population?
So those terms come from the score on the indices, and that there's a median, which is 100. That is the median with the bell curve. And so at the very ends, I hope I'm remembering these correctly. They're like in the lower portion of the population, but most people fall in the top part of the bell curve where, that's that average range. And so as we get further away from the bell curve, like the top of the bell curve, that's where those other ranges come in. And so very low means that he's in the lowest portion. And then I'm trying to remember the other one, I'm sorry. And then the other one is right before that one. And the way that it's not a label that I just select. These are labels that are provided in the manual so if they have this score for the indices, this is, the label that they would get of like very low, below average, so forth.
Are any of these measures or the Wechsler test used in any diagnostic way for diagnosing anything like intellectual disability or learning disability or things of that nature?
Yes, they can be.
Is there a reason you didn't make a diagnosis using this based upon that?
Overall, his full scale IQ was in I believe it was in the average or below average range. And also there wasn't concerns for an intellectual disability based on the information from that test or his ability to, he was taking care of his activities for daily living, like that means, like being able to go to treatment or, he's doing all these things that he needs to do for his daily living. And so that means that it did not appear that he met criteria for an intellectual disability based on the information I have at this time.
Because basically he functions in a society.
For the most, yeah. I mean, people with intellectual disabilities can function as well. They just might need extra support. It depends on the level of their intellectual disability.
And he just doesn't meet the criteria for that.
That is correct.
On page 6, you talked with Mr. Stewart a bit about him going through his attorneys. Did he explain to you why he terminated each attorney that he terminated?
I don't believe we discussed to that depth, but he did explain that he felt that his attorneys were not listening to him or, did not have like correct information about him and were presenting inaccurate information. And he also talked about not really understanding, when he's asked questions of his attorneys, not really understanding the answers that he's gotten. He also had mentioned sometimes too, like they felt rushed. And so he wasn't always able to ask all the questions he needed or to be able to like ask for further information.
Did he complain at all that he was having trouble explaining his position to any of his attorneys?
Could you clarify what you mean by that?
Communication with counsel or assisting counsel is a two-way street, right? They talk to you, we talk back. Did he complain about having difficulties explaining what he wants to have happen in his case to his counsel?
I don't believe we discussed that explicitly. He did give examples of not understanding, the process, and not understanding why his attorneys were wanting him to do certain things or plead certain ways or, how the case would go if he did enter those pleas.
Do Do you know what stage the proceedings are currently at right now in this case?
I believe he entered a plea and now we're at sentencing. Is that correct?
Right. So if Mr. Stewart wanted to have a trial now, would it be accurate to say he'd need the judge to order it as he no longer has the right?
From my understanding, once it's gone to sentencing, he would have to be sentenced and then he would have to file an appeal. But if he's entered a guilty plea, then he's giving up his right to an appeal.
Are you familiar with the ability of some people to try to withdraw their pleas after they enter the guilty plea and prior to sentencing?
I believe it was prior to sentencing. I'm not sure if it's possible to do that after you've already made it to sentencing.
So you're not exactly an expert on like the legal part of it. You're an expert on the cognition and the mind and the mental aspect of it.
I believe that I have a fairly basic understanding of how the criminal system works, and I'm able to use that information whenever discussing the competency process and some of the legal terms and all of that.
Do you know what a person would have to do to withdraw their plea after a plea and before sentencing?
I can take a guess, but I don't know. I couldn't say with certainty.
Okay, it's not a trick question or anything. I was just asking if you had that knowledge.
I believe that they would, through their attorney, file or have a motion to withdraw, file a motion to withdraw it, but I could be mistaken.
So you can answer hypotheticals and abstract questions, correct?
Potentially, yeah.
So if we had an individual who directed his attorney to raise competency for strategic reasons to create a basis for plea withdrawal, would that show that they did understand that what their position is on the case and they understand what their options are?
Just to clarify, you're saying the hypothetical is that a client is specifically directing their attorney to say, I want you to raise competency because I want to withdraw my plea. Is that correct?
Yes.
I mean, hypothetically, if the client understands and that was they brought that up of their own accord and they hadn't gone any additional information. But that also seems like a very high level knowledge of the legal system without any input or information from their attorney for a client to have.
So that would be indicative of someone having high understanding of the proceedings and understanding of the process.
Based on the information that you just gave me, yes.
And if that person terminates counsel because they wouldn't do that, that would be indicative of them controlling the representation. They know they decide who their attorney is and what the goals of the representation are.
Hypothetically, it sounds like it. Yes.
Okay. So I want to go back to this case. So we're away from the realm of the hypothetical.
Mm-hmm.
The concern in this case is not that Stewart is incapable of engaging in reasoning. It's that information has to be presented to him slowly, repetitively, and in person. Am I reading that right?
Yes. And that he needs to have the opportunity to ask a lot of questions and to be able to get that information, because it seems like there's times that he doesn't understand it. He required additional explanation. Sometimes you have to shift the way that you're providing the information or explaining something as well.
Why would outpatient competency restoration be necessary? Wouldn't an attorney be best to do that, especially given the complicated procedural posture Mr. Stewart's is in?
It seems as though, based on what, Mr. Stewart had told me, it seems that he has asked his attorney questions, multiple attorneys questions, and he still did not seem to understand it. And even when I provided explanations, trying various ways of changing my question or simplifying the question, it took a lot of effort, which is why, honestly, our competency evaluation took. Normally my competency, just the interview, not the testing, but just the interview typically only lasts an hour.
I'm
And
just
we
gonna
took,
stop you
Oh,
right
okay.
here. You're just
Sorry.
speaking a little fast.
Oh, I'm so
And
sorry.
when it gets fast for me, I know it's super fast for my court
Okay.
reporter. And
Okay.
so I know that you're in the hot seat right now, but if you can just slow down and just take a breath, then it'll be easier for all of us.
Of course, I'm so sorry about that.
That's okay.
I had to simplify my questions. I had to try to ask them in different ways. And then whenever, like I said, prior interviews would typically only last an hour. I had to take additional time with him in order to help give those like explanations and simplifications. And he still struggled with that. And so, attorney's time is very, attorneys are typically spread thin, and they don't always have additional time to be able to provide additional education and make sure that their clients are able to understand that information. And so based on that, using outpatient treatment, he would be able to receive, the extra time to make sure he's understanding it. They'll check in with him, to make sure that he's retaining the information, or if he's confused some information, they're able to provide that education again.
So if an attorney did just, let's say Attorney White takes the time out of his schedule and he just has the frequent meetings and does the hours-long meetings to really make sure Mr. Stewart understands, would that be enough?
I honestly don't know. Because,
But the information,
oh, go ahead.
but the information that he needs to learn through outpatient competency restoration, it's purely legal information.
They also learn how to apply that legal information to their case.
And this is different than what the attorney's job is in the case.
They make sure that they understand the process. So for example, whenever we were talking about the different plea options, he had struggled to be able to discuss like the outcome of some of the plea options, despite receiving tutorials on that. And so if he's not able to understand that, then he wouldn't be able to apply it to his case, which was evident and, during our evaluation. And so I unfortunately cannot speak to like exactly how many like times he would need the information repeated, or, how long it would stick with him, in between. I just know what I saw in my snapshot of time. And so I honestly cannot answer whether or not the attorney would be able to provide that information. All I know is that, at least with outpatient competency restoration, then there would be consistent times that they're following up to ensure that, they're remembering it, they're able to apply it, and that they completely understand it before things move forward.
Okay. So you mentioned in that explanation that there were problems with some of the things Mr. Stewart described for the legal terms. Could you explain that with a little more detail?
Is there a a specific time, or a specific like definition, or just in general?
Which specific, you said that he doesn't understand in the report some of the plea options, that he doesn't understand what the consequences would be. Could you give more detail about what about his explanations is insufficient?
May I refresh my memory?
You may refresh your recollection by reviewing your report. Once you have refreshed your recollection, please place your report back down.
Yes. So he was not able to explain like what, even after the tutorial, he wasn't able to explain what would happen after someone enters a not guilty by reason of insanity plea, or a no contest plea, or a not guilty plea. He just said, he was like, I'm not sure. We have all these court dates. I guess that's why we're here. He was unable to provide an accurate response.
You write there are 4 plea options. Did you not talk with Mr. Stewart about Alfred, please?
I did not discuss that one with him, no.
Why did you pick not guilty by reason of insanity to include in ones to discuss with Mr. Stewart?
Those are the 4 that I've always been trained on to discuss with them.
Okay, but that's a more complicated one than the other 3, you'd agree?
Not necessarily. The way I explain it is that someone has a mental health issue that impacts their ability to know the difference between right and wrong at the time of their crime. And I typically give an example. I mean, we were able to help people at the state hospital understand the definition for it.
Is there any possibility that Mr. Stewart could have engaged in what's sometimes called malingering in his claims of not knowing or understanding things?
He was fairly consistent in, struggling to remember some things, but, he was able to learn others. He definitely seemed a bit more fatigued by the end of our interview. And it seemed like it was consistent across both the prior report and my report. So while it is always possible, someone is malingering, due to the consistency, that was not a concern for me.
And by consistency, you're saying he behaved the same way in front of both doctors assessing him for competency.
That is correct. And he demonstrated the ability, he did try to learn and he would engage with me, and he was showing effort throughout our evaluation.
And did he show some success when he was trying with you on topics?
Of course, yes.
So when he tries and he's given enough time, he can learn things.
Yes.
And he's not a person where he requires any sort of medications or anything like that to restore to competency.
I did not assess that, but I didn't provide a diagnosis that would typically bring forth concerns about medication. I can't prescribe medications, and so that's kind of outside my scope.
He doesn't show any indicia of having a disorder of delusion or psychotic symptoms.
No.
He shows no signs of long-term degenerative brain disorder.
I did not do a neuropsychological evaluation. So I did not, we don't provide neuropsychological evaluations through our practice. So I did not look at, degenerative disorders.
And you didn't look at or find any evidence of any mental illness that would be the cause of competency.
No, it was more so the concerns of his difficulties with memory and processing speed that were interfering with his ability to retain the information and to
Okay.
apply the information.
I have no other questions.
All right, Mr. White.
All right, thank you. I have a couple questions. I'm going to skip some questions here, Dr. Brady, about qualifications and training. But I want to know how many competency evaluations do you think you've performed in the state of Wisconsin?
Maybe 17?
Okay, and you spent a considerable amount of time with this defendant. Did you say it was over 200 minutes?
Yes, that is correct.
And how much time is an average amount when you normally do these interviews?
Typically about an hour, but that does not include testing as well.
Okay. So in your experience, this interview took longer than average?
That is correct.
Is that because you had to take additional time for answering questions and explaining things to Mr. Stewart?
That is correct.
Then just looking at the conclusions here, in general, you state you concluded that Mr. Stewart's not competent at this time, but he's likely to be restored within the time frame if provided treatment. Is that still your finding today?
Yes, sir.
And what observations from your evaluation led you to finding incompetency?
It was again based on, his demonstration of I'm providing this information to him and explaining it to him, and he would he would confuse some of the terms, or he wouldn't remember, some of the information, especially information where it wasn't, for example, like, okay, let's just remember these 4 plea options, and then he could recall that. But then the more detailed information, again, going back to like what happens, what are some possible outcomes with these, they were more difficult for him to recall and to apply. And he would become tangential at times as well, but he was able to respond to redirection, which led me to believe also that he would be restorable.
Okay, thank you. Just to be clear, I think you already testified, there's no exact mental disease or defect that you diagnosed here, right?
No, unfortunately, there's not one in the DSM that's strictly related to the deficiencies and working memory and processing speed. Based on the information I have.
And is that okay for you to make this finding that he's not competent without there being specific mental illness?
I recognize that it might seem a bit, odd to not have that. However, these deficiencies are interfering with his ability to engage with the legal proceedings and to understand and apply it. So that is why I opined that he wasn't competent, but is likely to be restored.
Okay. And could Mr. Stewart adequately explain to you the roles of the judge, prosecutor, or defense attorney?
He struggled a little bit initially with the defense attorney, but yes, after being provided tutorials, he was able to explain those roles.
Okay. About the facts of the case, did he provide you a logical narrative of the allegations?
Um, for the most part, yeah, he sometimes would get caught up a little bit on some things that were related to like why, the the plea agreement or, the one of the charges didn't quite, he didn't understand why that was a charge versus, like what was being said had happened.
Okay. And when he described the litigation history of this case, including the plea hearing that you just talked about, did it sound like he had an issue with understanding the litigation itself?
It did. He seemed a bit confused about the plea, like the plea itself. And that he said like everything's over with, like everything's done in the case. Why are we still having to meet? He didn't seem to understand that there has to be like a sentencing hearing. And so he was confused about that.
And did he describe to you his own understanding of the case?
He did.
Okay. And how was that?
Um, it was tangential at times, but he described having a lot of questions and confusion, and he felt there was a lot of information about himself that was inaccurate, that was being provided. And so, it seemed like, well, not it seemed, he was saying that he was not understood by his attorneys and that he wasn't understanding the process.
Okay, and I know you testified a little bit about that on page 6 of your report, just that he had some issues with understanding his previous lawyers. Is that true?
That is correct. That's what he told me.
And looking at just the conditions here with the memory and retaining information, and then the processing speed, how does that impair a person's ability to understand court procedures?
If they're struggling to be able to retain information that they're receiving, for example, verbally, or if they're provided visual information and trying to use that information to make decisions, visual information trying to make that decisions, then that can obviously interfere with their ability to learn, to retain and learn the information quickly whenever they're meeting with their attorney, or if they're provided just, a brief, well, these are your options, X, Y, Z, now make a decision. These are what they mean. He would definitely need more time. He would need more questions. He would need to understand the implications of each one. And so his working memory and his processing speed all interfere with that, or well, not interfere necessarily, but inhibit that a little bit and requires extra support.
Okay, and I guess that leads into the next part here about the outpatient competency restoration program. What about this led you to believe he's likely to regain?
Because he was able to learn some of the concepts that we were discussing, and he was able to retain some of them. And so to me, that suggests that, if he's given extra time and he's given the extra support, that he would be able to learn and apply it through treatment.
Okay, you described attempting a tutorial with him regarding the plea options. Did he struggle with that?
Could you clarify what you mean by that?
Did he struggle with working through the tutorial, just with the way you presented it and kind of how he processed it?
Yes, so for example, the way I would present a tutorial is, okay, so these are the 4 plea options, and I would list them and then, make sure he understood that. And then, ask if he had any questions about them. And then if he didn't, then we would proceed on with what we were, the other questions. And then I would come back to it a couple of minutes later and ask him about it to see if he retained the information that I provided him. And if he was confused about it, for example, when we were going over like the not guilty by reason of insanity plea, I might offer an example to try and clarify, or trying to explain like, okay, if A happens, then B happens, and this is kind of like a decision tree. And he struggled with those as well, especially once we were talking about his actual case.
Okay. And the restoration program, do they use tutorials kind of like the way you described?
Typically, yes. I don't have like a specific, obviously like treatment program in mind. The program that I worked at, we had a packet, and then we would also do group settings and individual. We would talk to them about it. We'd make sure that they had a good foundation of their of like just the legal knowledge. And then once they had that, then we would start applying it to their case. Okay, so now that you understand the difference between these pleas, if you were to enter, any of these pleas in your case, what would your outcome be? What are the potential, like, could it be a fine? Could it be, incarceration? Probation, like what could potentially be the outcomes and why is that? And we just really make sure that they understand that. And then they would also have homework as well, just to make sure that they're reinforcing that learning process and getting exposure consistently to those materials.
Okay. Then kind of the last part I have here for you is, do you have any training or experience with identifying dishonesty during your interviews?
I do, yes. I've
How-
provided malingering tools in the past whenever there were inconsistencies in the individual's responses, or they weren't effortful at all during, the interview.
Okay. How do you prevent someone from kind of cheating the system or gaming this process?
So we could potentially use like a malingering measure to just kind of show like, hey, there were concerns about this. If they're presenting in a way that seems that they're trying to game or be dishonest during their interview. And but at the end of the day, unfortunately, there's only so much I can do. I can just present the information, and it's up to the attorneys and the judge to kind of, I guess, piece that out further.
Okay. You didn't use one of these malingering tools or measurements here, right?
I did not.
Is that because you didn't find a basis for it?
That is correct. He was effortful. He was engaged. He wasn't shutting down. He wasn't refusing to answer questions. He wasn't just saying, I don't know. Like, he was truly trying to work through it. And I could see his thought process when he would provide an answer. And I'd ask, well, why is that? Even if it was the incorrect answer, I would still ask, well, why is that? And so that way I could see where the confusion was coming from. Like if he was mixing up terms, or he just didn't understand how, a process worked. And so that indicated to me that he was not malingering or trying to game the system, at least during our interview.
Okay. And then just to summarize that, you didn't think there was any indication that he was exaggerating, faking, or malingering some symptoms?
That's correct.
Okay. Part of the prosecutor's questions for you today included kind of a lengthy hypothetical about if a defendant were to direct their attorney to raise competency using a high level of reasoning, then to withdraw the guilty plea Is that, just in your opinion, is that something that you think the defendant was up to?
No, he honestly really struggled to understand what competency is. And I had to provide several tutorials related to that specifically.
Okay. Thank you. No other questions?
Thank you, Mr. Schmidt. Additional questions?
Yes, so he claimed not to know what competency is.
That is correct. He wasn't sure, like everything that it entailed, that, knowing he did learn that, he had to know like the court lingo and things like that. But he didn't understand that, he needed to know the process, how the court proceedings go and things like that. But he did know like the roles and everything. But when I specifically asked, like specifically related to the term, what does competency mean? He initially, wasn't sure.
Wouldn't that be surprising considering he already talked to a previous doctor who would have gone over the same thing with him?
Not necessarily, considering he does struggle with some memory issues. And even after I had talked to him about some things in the short term, he still struggled to remember them. So I wasn't surprised by that.
You talked about how working memory capacity and slow processing speed could negatively affect a person's ability to comprehend like a plea in court, correct?
That is correct.
But if a person, say, had, a considerable amount of time, like months to consider a plea, then those concerns would be less.
When you say like having months to consider a plea, are you just meaning like they're told these are your options and then they take time to think about it? Or are they getting information during that time and being able to ask consistent questions and get additional information?
Let's say the latter.
Mhm. And I'm sorry, can you remind me of the question again? Sorry, I was like, I gave my my example and then I was like, wait.
I think your question raises a question I'd like to ask you.
Okay, that's
Do you
fine.
consider it a measure of competency what the relationship is between the defendant and their attorney?
That is one piece of it, is are they able to effectively assist their attorney in their own defense?
So if a defendant just doesn't like their attorney, doesn't want to talk to them, doesn't trust them, that's something that goes against competency.
It depends. If they're not trusting them or understanding them, due to, like a mental health issue, or, they're not getting their questions answered, or, like they're trying, like truly trying to like work with their attorney, but they're needing additional explanations, or more information that their attorney isn't able to provide because they don't understand it, or like because the client's not understanding and that's why they need the more information, then yes, that would go in. But if it's just an interpersonal issue where they're like, I don't like this person I'm working with, so I'm choosing, like I don't trust them or I don't want to work with them, and they're not effortful in trying to have this relationship with their attorney, then I would not consider that part as part of the competency.
But you didn't get into the deep specifics of the relationships with counsel in this case, correct?
He did discuss that he had a lot of questions, and that he doesn't always get the answers to his questions, and he didn't always understand the question or the answers that he was getting, and that the attorneys weren't always able to follow up with him. And then he also discussed that, I know one really big sticking point that came up during our interview for him was, for example, being told he, was self-employed, and he was like, I never did that. My attorney clearly, either didn't listen to me or something wasn't, the attorney didn't understand what I was saying. And so that shows that there is definitely some communication issues. I don't know where they lie because, there's two sides to every story. But there were definitely some communication issues and concerns between them as well. And so he did discuss those, like those areas of difficulties he had with his attorney.
Okay, I have no other questions.
Any additional questions, Mr. White?
No, thank you.
All right, thank you. You are excused. Thank you, Dr. Brady.
Thank you. Have a good one.
Next witness, Mr. Schmidt.
I call Scott Locker.
Scott Locker, please come forward, raise your right hand. You'll be sworn in and come have a seat at the witness stand.
You swear that the testimony you're about to provide today in this matter is the truth, the whole truth, and nothing but the truth?
Kathy related to one of, anyone know a Kathy? Mr. Chapman, I do not yet have Mr. White.
Well, that's interesting. I thought I was here for Mr. Collins. One second.
Oh, no, 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 you are. I'm talking about Attorney White.
Attorney White. Okay, good. I thought my calendar was wrong.
No, okay, he's walking in right now. All right, Mr. White, you can come on up. We're gonna do Mr. Daniels briefly first.
Okay.
We will go on the record in the matter 25 CF 55 26 CM 81 State of Wisconsin versus Colin Daniels. The state appears through District Attorney Kevin Schmidt in person. I do have Nicholas White, Defense Counsel in person, Daniel Chapman, Defense Counsel for the misdemeanor matter by video conferencing with approval of the court. We do have Colin Daniels appearing by video conferencing in custody in Burnett County Jail. We're set today in this matter. The court is set for a status conference in the misdemeanor matter with Daniel Chapman. The court did set a sentencing hearing on revocation for Mr. Daniels' other matters simply because I was aware that you would be here, Mr. White, for your other case. Are we able to proceed with the sentencing after revocation or set it for another date shortly?
Your Honor, I'm prepared to move forward with the sentencing today.
We must do that and take care of the matter briefly, but I have reviewed the packet and I don't believe that this should take very long or it should be very lengthy. And Mr. Schmidt, we do have spillover time for the other hearing. Okay, so Mr. Collins or Daniels, you are appearing by video conferencing. Do you understand you have the right to be here with your attorney, Mr. White, in person?
Yeah,
Are you okay with appearing by video conferencing, or do you want to reschedule this and be in person?
I'm fine with the video conference.
Okay, if at any time you have any questions or concerns and you need to speak with your attorney, let me know and I will have him go into Zoom and I will send you to a confidential breakout session, okay?
All right.
All right. Are we in victims' rights compliance?
Yes.
Okay. The court has reviewed, well, the victim statement for the other matter, Mr. Chapman is representing, but there is not one in this case. All right, so the court has reviewed the packet. Has the state received and reviewed the packet?
I received it. I reviewed it. I have no corrections. I believe the credit is probably agreed at 94 days.
94 days. All right. Mr. White, have you received the packet and reviewed it?
Yes, I have, Your Honor. I don't know any errors or omissions. I would stipulate to 94 days sentence credit. That'd be the time that he's been in custody since this revocation hold, also including 6 days from the original arrest to cash bond being posted. I had a chance to review the packet with Mr. Daniels. We're prepared to move forward today.
All right, Mr. Schmidt, argument and sentencing recommendation, please.
I'm asking the court to follow DOC's recommendation in this case. DOC recommends 9 months. There are 12 months available, making this a 75% sentence. I think the reasons for following this is the violation that triggered the revocation also involved alcohol, which is concerning, especially since the revocation packet indicates he hasn't done AODA. It is to his benefit that he's done prior appointments and skill building, and they had positive input about that. But the lack of AODA on a drinking violation leading to a violation that's also related to drinking, plus one other drinking violation on supervision that didn't result in revocation, shows he had multiple strikes. I think 9 months is reasonable considering the facts of the original 2025 case. It was a serious case that got pled down because of hopes of treating alcohol addiction. That didn't happen, so the court should follow DOC's recommendation. Thank you.
Mr. White.
Thanks, Your Honor. We're recommending that you consider a 6-month jail sentence here. Just a few notes on the prosecutor's comments here. I believe looking at the plea questionnaire waiver of rights, misdemeanor failure to stop, it states that the maximum penalty upon conviction would be 9 months or $10,000 fine. My understanding here from review of that document and then some of the statutes is that this is actually a 9-month maximum sentence. That was just my understanding. Maybe wrong, maybe looking at the wrong thing. But with that in mind, it appears that DOC and the state is asking for the maximum sentence, which I think we all understand is somewhat rare. The maximum sentence in a case is used for the most severe situations, the worst of that particular crime that could be possible. Your Honor, I don't think that this is the most egregious type of fleeing that occurred. Just reviewing the criminal complaint. Let's see.
And I'm just going to, before you continue to argue,
Yeah.
Mr. Schmidt, in my review of Wisconsin statute 346.04 paren 2T, I'm finding the maximum possible penalty is 9 months of incarceration and a $10,000 fine limit.
Yeah, I misspoke. I saw the unclassified misdemeanor and I forgot it has the penalty of a Class A misdemeanor, even though it's unclassified.
Okay, does that change your argument or recommendation to the court? Because you were arguing it's a 75% sentence versus what the max would be, therefore follow DOC.
It doesn't. I consider the violation more serious than the underlying offense.
Okay, sorry, Mr. White, you may continue.
Thanks, Judge. I was just looking for the notes that I had on the incident. I didn't represent Mr. Daniels on that, but reviewing it, looks like it was a motorcycle chase. He was speeding around midnight. The officer had lights and a siren on. The defendant must have noticed that. He did not stop. He had nearly crashed his motorcycle on a Gandhi Dancer trail. That put himself in danger and harm's way. Anybody else that was there could have been endangered as well. I see that this started off as a serious, very serious case by being a felony, was negotiated down to a misdemeanor. I think part of that is just that they eventually found Mr. Daniels. He admitted to drinking. He eventually complied and admitted to the evasion. He knew he was on probation. He shouldn't have been drinking. Hearing the prosecutor's comments, I also note that this seems to have happened before, more like a deja vu where Mr. Daniels has been on supervision. He was told not to drink. And unfortunately, he relapsed. He went out to drink. And when he was drinking, he made some very bad decisions. Now there's a new pending case. Not the same type of facts, but similar type of situation. Mr. Daniels on supervision, drinking, made some bad decisions, and definitely scared some people in the new incident. Looking at the way the misdemeanor case was resolved, he did have a traffic ticket. The rest of it was dismissed and then the felony reduced to a misdemeanor. With that all being said, I think that it's fair to go below the maximum possible sentence here. we'd ask you to consider 6 months. My client has some goals upon release. He's got a home and a truck that's waiting for him. That tells me that he has stable residency. He's got a way to make it to work. He's got a way to make it to probation or wherever else he needs to go. I believe that he has supervision remaining, even though this was revoked. I believe he has a different case that he's still under supervision with. So he's still going to have to follow through with whatever's ordered there with treatment, sobriety, and the like. Looking at his school options, he may have to go back for something better to give him some more job options in the future. He lost his job while being incarcerated, but he's able to work for himself. He may be looking at getting a union job. And I think that all goes towards his character and his stability. I think his intent is to remain in a relationship with Jada. She's referenced in the revocation packet. I believe she's a victim in the new case. But there would be some need there for some counseling, some personal things need to change between these people, and Mr. Daniels needs to make some changes. He understands that. So I know that he's been busy while he's been in custody. He's been doing some courses in the jail. He's been going to the church there. I don't think he did that before being in custody. And just brings me to my point that while he's been in custody, he started off strong doing workbooks on addiction, meeting with a pastor, Sunday and Tuesday church and Bible studies. Your Honor, I'd argue that at the beginning, when someone's in custody, it's when the punishment is most effective to them. But at some point, being in custody is no longer providing the right kind of punishment. It's just kind of dragging a person down and hurting their ability to recover afterwards and be a more productive citizen. So I'd ask you to consider the 6 months here. Thank you.
Thank you. Mr. Daniels, do you care to make a statement here today? You do not have to, but it's your only time to let me know anything you would like me to know.
I kind of just wrote something up here before I'd like to say something.
If you're going to read something, please read it slowly and enunciate your words and make sure that you speak pretty loudly so that my court reporter can take everything down.
Okay. I'd like to apologize for taking up time in court, and I'd also like to apologize to Jada. Since I've been in custody, she's been taking care of our daughter alone. And my aunt, she's been taking care of my dog. Being in jail, I've learned that I'm powerless under the influence of alcohol by attending AA, along with help from my pastor, Jeff, who's been working through the crossroads away from addiction 10 steps with me every Monday. He's shown me that I have a lot of positive support and better ways of dealing with issues and negative emotions by helping me know God and turn from alcohol or other distractions that I relied on to mask hard feelings. He's helped influence me on making a plan to a better life with more structure and positive decisions. I plan to keep seeing him and get an AA sponsor and attend more meetings when I get out, along with looking into couples counseling with Jada to strengthen our relationship, learn to communicate with each other better. This slip up has jeopardized a lot in my life. I lost a great job and let loved ones down. My daughter, my puppy, and Jada the most. I just want to get back on track and focus on a better life. Not a bad person, I just messed up the progress I was making. My time has been very helpful here in many ways, but the biggest one is that I don't ever want to come back to jail, and I'll do whatever it takes from happening again. Thanks for letting me speak.
Thank you, Mr. Daniels. The court has received and reviewed the revocation order and warrant, and quite honestly, I do remember the facts of this case very clearly, and they were stated in a good summary by Mr. White on the record. This was serious because it involved alcohol and it involved you riding on a motorcycle at excessive speeds and trying to flee and elude an officer. You could have been injured, you could have been hurt, and God forbid you could have injured or hurt someone else. But thankfully, none of that occurred. You don't have an extensive criminal history. I'm not aware, and I'm not saying that Mr. White is incorrect. It could be Minnesota. I don't have full access to Minnesota, but I'm not aware that you will be continued to be on probation after this, Mr. Schmidt.
He's on supervision for the same OWI that out of Minnesota that he was on the 2025 case. He still is.
Okay, so you're still on that supervision. Okay, so you will still be on supervision. And you still have the ability to complete the necessary requirements on supervision, including that AODA assessment and more skill building or cognitive thinking type of programs, which that is a positive here. Your statement sounds like you have had a lot of self-reflection and that you are taking this seriously, and that when you are released, whenever that may be, that you will then move forward in a positive way because you understand the significant and serious impact that your actions have upon your family, especially upon your young child who has now had to be away from you for a very lengthy amount of time. I don't think that this is a maximum possible penalty case, again, because you don't have a significant criminal history. This was serious, but I don't think that the community is going to be harmed or at risk if you have a lesser sentence than the maximum penalty, because again, you're going to be on supervision and you do have this other case that Mr. Chapman is representing you on. I don't know where that's going or where we are with that at the moment. But because of the facts stated on the record and the fact that you can continue to improve yourself and go to church and do the AODA and do the cognitive thinking classes, the court is going to follow the recommendation of the defense here, and I'm going to sentence you to 6 months of incarceration with 94 days of jail credit. You will get good time. So you do have some time to continue to sit and to think about this, because hopefully this is going to be something that will not happen again. I like your way of thinking and the courses and the therapies and the plan that you are working out. So please put that into fruition. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I believe that is all that we have to cover. Any fines and fees will be converted to a civil judgment. You're still going to owe them, and if you fail to pay them, the court could issue a warrant and you could sit up to 6 months in jail. Mr. Chapman, what are we doing with the other matter? Are we setting it for a status? Are we setting it for a plea and sentencing? I know that there was a plea offer, but it entailed Mr. Daniels being released from custody and having time to complete certain things. My guess is an AODA assessment and whatnot.
I'm thinking that given the sentence today, we should set it for a status conference approximately 2 months out. By then, I will expect Mr. Daniels will come back with at least his AODA scheduled. The plea agreements that we're hoping for in my case will involve him doing that up front.
So you're looking for a date and time when he can be out of custody? What about
Out of custody and schedule the assessment.
would October 8th be too soon?
No, I would not say so. It might be something he can do from the jail too. We will work on it.
All right, October 8th, 9 o'clock. Does that work, Mr. Chapman?
It doesn't actually. I'm in St. Croix at 9:30.
Oh, you are coming back October 5th at 9, but
Yes.
let's do October 5th at 9. And then we will just get an update on where Mr. Daniels is and what we need to do and if we're setting it for something else after that.
Thank you.
All right, thank you. We are adjourned.
Your Honor, on the sentencing case,
Yes.
it's something I've been informed from Mr. Daniels' parents that there's a death in the family. There's a funeral set up with visitation at a funeral home and graveside service. I got a message that that's set up for September 3rd on a Thursday. I just wanted to let Your Honor know that ahead of time. This might be a situation where we'd be asking for a furlough just for that day.
Thank you for the notification. Please put it in writing. Let me know who has passed and the relation. And again, those specific dates and times.
Okay, will do.
All right, thank you. Anything else?
No, that was it.
All right, thank you. We are adjourned. All right, Mr. Stewart. We will go on the record in the matter 24 CF 163, State of Wisconsin versus Christopher Stewart. The state appears through District Attorney Kevin Schmidt in person. We have Nicholas White, Defense Counsel, in person with Mr. Stewart. We're set here today in this matter for a competency hearing. The court has received and reviewed, I believe this is the second competency report that the court has received. The report indicates that Mr. Stewart is not competent, but likely to regain competency. Mr. Schmidt, you are contesting that finding?
Well, first we need to know what Mr. Stewart's
Yeah, I
position
guess.
is.
I'm gonna, Mr. Stewart and Mr. White, have you received and reviewed that psychological evaluation and report?
Yes, Your Honor. I received and reviewed both of them. I informed Mr. Stewart of the results from both evaluations. I'm in agreement on my own part with the doctor's evaluations. Both of the both halves of that, the finding of incompetency, and then the second part being the likelihood of regaining competency within the time frame. I believe here is 12 months.
And Mr. Stewart he is the person who is affected here, so he does get to indicate whether or not he does contest it or whether or not he agrees with it.
Okay, and I'll have him
I
answer
mean, you
that.
can speak for him, but because you're his attorney, but just for the record.
I'll agree with the doctors.
All right, so Mr. Schmidt, are you contesting the reports?
Yes, I would like to take evidence.
Okay, I do have Dr. Brady who is waiting. Are you calling Dr. Brady as a witness?
Yes, is Dr. Stepp in there as well?
No.
Okay.
I
I'm fine
only
with,
have Dr. Brady and 3 other individuals who I don't believe are doctors, but an Autumn, a Michael, and a Kathy, and an observer who is the grandma.
I'm fine with doing just Dr. Brady as long as Mr. Stewart and his counsel are, because this is the hearing when there's an opportunity to take evidence.
So, Mr. White, would you like to have both doctors testify, or simply are you satisfied with having Dr. Brady testify? And wasn't Dr. Balderas notified and subpoenaed to be here today?
I don't know, he was the court doctor.
Well, the court doesn't subpoena him.
This courtroom hearing starts with a simple rent case, but things quickly take an unexpected turn when the judge discovers that Miss Taylor has an outstanding warrant. The judge tells her that she needs to come to court immediately to address it, but Taylor appears genuinely confused and keeps asking what the warrant is for. According to the court, the warrant is connected to non-payment, but Taylor insists that she never received any notice and had no idea there was a warrant waiting for her. The judge, clearly frustrated, says he is tired of hearing people act completely shocked when they discover they have outstanding warrants. Taylor explains that she only came to court for her rent case and was not expecting to deal with a criminal matter at the same time, but the judge makes it clear that the warrant cannot simply be ignored. He gives her a limited amount of time to appear in person and warns that if she does not show up, the court will move forward with a default judgment in her landlord-tenant case. When Taylor finally appears to address the warrant, the judge reminds her that she had previously been ordered to make payments. According to the court, she was told to pay $100 and then continue with weekly payments, but she failed to follow through. The judge becomes increasingly frustrated because Taylor initially acts as though she has no memory of ever appearing before him. He tells her not to interrupt and says that pretending to have no idea what happened only makes the situation worse. Taylor eventually apologizes and explains that she was confused because she believed the court appearance was only about her rent problems. She says she is currently unemployed, struggling financially, and trying to keep a roof over her head. But the judge points out that her case has been pending for nearly 2 years and questions why she never came back to court to explain her situation when she lost her job. Then comes one of the judge's sharpest moments. Using a baseball analogy, he tells her that sometimes a person needs to realize when they are already far behind instead of continuing to argue. The message is clear. Taylor needs to stop fighting with the